Okay, so let's go ahead and get started. We're going to pick up here in Chapter 4, the 8th outline, looking at civil rights, more narrowly, civil liberties. And we're going to pick up here with free press. So just make sure you're watching this video before class on Wednesday so we can stay in sequence. Of course, Monday you're taking your exam. So we'll pick up with basically where we leave off after this video lecture. So we're going to go ahead and pick up with the First Amendment right of free press. Now, we're continuing our discussion on civil rights and civil liberties, and more narrowly, actually, the First Amendment. The First Amendment has a whole host of rights, civil liberties, and this is actually an enumerated civil liberty. And remember what civil liberties are, of course, is they're freedoms from government, right? Remember, we just started this course, we talked about freedom to and freedom from. This is really one of those freedoms too. And the framers of the Constitution were very concerned about the right of free press and that it's unencumbered from government restrictions, in the sense that there shouldn't be any type of government approval or government okay for something to be published, even if it is negative, even if it's wrong, right? Even if it chastises or criticizes the government. The framers were very, very conscious about this. So if you actually look at the First Amendment, as we've already read it, there's an enumerated civil liberty there, the right of free press. So what we're going to do is go ahead and start with prior restraint. And on some of these situations, I gave you cases, and others that I didn't. But we're going to start with the 1931 case, Neer versus Minnesota. Now, the question here is whether government can actually prohibit the publication of any type of media, okay? Now, in 1931, of course, it was newspapers. This is a case that involves newspapers. More specifically, the case facts here, we had a journalist who was reporting about corruption in local government. Local government found out about this and actually had instituted a ban, an injunction against the actual publication of the article that would have, the series of articles that would have continued, whereby the reporter was actually, J. Neer was actually reporting on the corruption. Now, the Supreme Court, even as far back as 1931, stated that free press means really no prior restraint. No restrictions on publication. So the idea is that given today in the year 2018, whether it be online or paper, what have you, over the airwaves, something being broadcasted, there is no requirement that government approve a message, nor can government enjoin, that is, say, put into place an injunction prohibiting some type of publication. Now, with that said, prior restraint, right, would actually be the prohibition, all right? So the First Amendment right of free press basically prohibits prior restraint. And think of prior restraint would be that the ability of government to step in and say, we're not going to allow this to be published. Now, with that said, all right, prior restraint, right, would be the injunction, the prohibition. We're removing that. But let's talk a little bit about what could happen afterwards, right? So let's say, what we already know, there cannot be any government restriction on the publication of the article or posting on web or over the airways or something like that. But what happens, however, if what is said, the message, the news, the press, etc., is wrong? All right? Or even worse, let's say it's defamatory, right? It injures somebody's good reputation, okay? Now, the First Amendment right of free press does not protect a journalist, news outlet, television station, whatever the media of the platform might be, from a defamation lawsuit, right? So perhaps the person who might be wrongly accused or associated with something, can they actually go back and sue the media outlet, the journalist, etc.? The answer is yes. So think about it this way. The First Amendment right of free press only protects the journalist, the media outlet, newspaper, radio station, television station, etc. All right, it only protects them from government interference with their publication. What does not do is it does not protect them from a defamation suit if what they're saying is wrong. Okay? Now, there are essentially two types of defamation. There's libel and slander. Libel is essentially anything that's written or broadcasted. Slander is actually just a smaller zone of defamation that's really just oral communication. And sometimes they're used interchangeably when they shouldn't. But most of your defamation cases happen to be libel cases, okay, as you kind of imagine what's in print. Okay, so no prior restraint, right? First Amendment right of free press prohibits prior restraint or that government interference with a publication, injunction, etc. But again, it doesn't protect the journalist or the news outlet from what might happen later. Okay, now let's fast forward about 40 years, or 40 years right on the nose, and talk about national security. Now, in law, there still is, right, a narrow exception to what we just discussed, right, for issues of national security. So the question becomes, right, can the United States government prohibit a publication in the media because of national security interests? Now, this becomes a pretty hairy area of law, so follow me, okay? Now, the 1971, the actual case is famously known as the Pentagon Papers case, and Daniel Ellsberg was well, he's younger then. He's still alive. He's actually 87 years old. He was a young economist working for the Rand Corporation. The Rand Corporation is this big global think tank, had been around for a long time, and they were doing some work on behalf of the United States government, more specifically the Pentagon, hence the Pentagon Papers. All right, this is the very famous New York Times versus United States case. All right. And Ellsberg's working there, and he's privy to some pretty sensitive materials, and he just lifts something, right? He just takes it out. And basically it was a report on, or really a series of reports on the Vietnam War, which would have had they become public, and later did, would have really discounted the American government's argument for being in Vietnam, and really kind of countered a lot of what the U.S. Defense Department was saying about potential for success in the Vietnam War. So he's an employee, and he basically takes this stuff out, right? And he's an employee for Rand. He's actually not working for the United States government. And he takes this stuff and gives it to the New York Times and the Washington Post. Now, interestingly enough, a couple of these articles had been published, and the Times was doing it actually in a series at the time. So the question becomes, can the United States government really step in and say, okay, no more publications. This is an issue of national security. Okay? Now, this is probably one of the most bizarre Supreme Court decisions ever. And in a larger constitutional law class, we would spend a lot more time kind of pulling it apart. But the interesting thing here was that the case was actually a per curiam opinion, but it wasn't unanimous, and it wasn't anonymous. It was one of these very, very bizarre cases, but it was actually short. All right, the Supreme Court had to act on it very, very quickly, almost instantaneously. Now, the Supreme Court ruled, yes, the United States government, the federal government, the Defense Department, etc., all right, all collectively together, can limit the ability of press to publish something that might interfere with national security. However, interestingly enough, they said this isn't it, right? They said, yeah, there's some concern for national security, but it's not great enough to prohibit the publication of what became known later on as the Pentagon Papers. So it's really kind of fascinating. The Supreme Court said, yeah, there's a national security exception, but not here, right? Not in the Pentagon Papers case. So what's interesting is that, here in the year 2018, several years later, frankly, the Supreme Court has never found, right, a case whereby national security was such a strong concern that publication, right, in the media could be stopped, could be prohibited, could be enjoined, right, through the legal measure, which is the injunction. So it's kind of interesting. The rules there, the Supreme Court just hasn't found a case where it would be possible. Now, I will tell you this: when you think about the right of free press and media outlets and how they act, they're actually very judicious about, pardon the pun, in the use of the word. They are very judicious in terms of what they would publish. And newspapers are pretty sensitive, and if they really thought something would jeopardize national security, they probably wouldn't publish it. All right, and there's all sorts of reasons for that. Reporters, if you didn't know this, they adhere to a very tight ethical code, and a lot of times we hear about the media kind of getting bashed, but it actually is a pretty ethical order, pretty ethical group of folks. All right. So again, if you take these two cases together, the Pentagon Papers case from 1971 and the Near case from 1931, you have an interesting situation where collectively the right of free press is very, very powerful, and you only have really one exception, but the Supreme Court hasn't even applied that one exception. Okay, so moving forward to just really kind of two issues, the reporter's privilege and press shield laws, which we'll kind of put together here. Many have argued, right, legal scholars, political scientists, etc., is that the First Amendment right of free press should be interpreted to allow for a reporter's privilege, whereby if a reporter is working with a particular source, a source that the reporter wants to protect, so the reporter can continue to go back to that source and ask for information, etc., kind of like a two-way street there. That, again, the First Amendment right of free press should be interpreted to allow for the reporter to say no to law enforcement when law enforcement says, I need to know who your source is. We need to know. We've got a criminal investigation going on. We should know who this person is to whom you're talking, whether it be a key witness or maybe even a criminal defendant or what have you. Okay, now the Supreme Court has never interpreted the First Amendment right of free press as having a reporter's privilege. So in other words, the constitutional rule that you want to get down in your notes is really this. If in a criminal investigation law enforcement demands that a reporter reveal sources, the reporter has to reveal it. Now again, to break this down a little bit, all right, only criminal investigations, not civil cases. Right? And it has to be law enforcement that's asking for the source. Now, with that said, if the reporter refuses, the reporter still refuses to reveal the source, the reporter can be locked up and held in contempt, right? And the question and that's happened. And the question becomes, well, for how long? Okay? Well, this is where things vary. I mean, reporters have been held in jail through the length of a grand jury investigation, which we're going to talk a little bit about the mechanics of a grand jury investigation here in a little bit, and or the conclusion of a trial. Right? It really depends on how long the judge wants to keep the reporter in jail. So again, that certainly might take some time. Okay, now let's look at press shield laws. Now, press shield laws, anytime you hear that, they're all state laws. Some states actually have done this on their own, right? Now, I like talking about this for a couple of reasons. Number one, it's a better reflection of the right of free press. But number two, remember when we first started talking about constitutional law, we've talked about it a couple of times in the courts chapter, we've talked about it a couple of times here in the civil liberties chapter. The Constitution, the United States Constitution, and how the Supreme Court interprets it really serves as a floor, right? And states, of course, can give greater protection. So in a situation rather like this, here the states that have enacted press shield laws have basically said, yeah, we're going to incorporate this reporter's privilege into our state code. So in any particular state, right, a reporter can tell law enforcement, no, I'm not giving you my source. I'm not revealing my source to you, right? And of course, you can't lock me up in jail, right? You can't put me in jail. Okay, so again, kind of putting those two things together, right? So no constitutional right, but some states have done that on their own. Okay, now let's talk a little bit about obscenity. Okay, now this is probably something we can put in different places. We're just going to attach it here to the right of free press, largely because our focus is really just going to be on what's printed or what might be broadcasted, things of that nature. But obscenity can be a bigger issue. If this were a class on media law or advertising law, we'd actually spend a lot more time on obscenity, largely because the fine line that our obscenity law creates can be the difference between a firm making money and a firm not making money, right? And so if a firm is in, let's just call, for lack of a better phrase, kind of in salacious activity, all right, and they're making money off of it, if something is not obscene, then they're going to be allowed to do it and be allowed to make money. If it's dubbed obscene, right, well, this is a limitation on the First Amendment right of free speech and free press, right? Okay, so let's go ahead and define obscenity. If something is viewed as obscene, it can be limited. Its print can be limited. Its description can be limited. Whatever the thing might be, right, that can also be limited. Okay. Now again, if you think about in regard to business, right, a publisher, a film production company, right, maybe one of those not so, kind of like a seedy bar or something like that. You can kind of imagine what might take place in some of those places, but you get the idea. So the fight is often, if we were to spend 3 weeks on looking at constitutional law in regard to obscenity, the real fight is generally between a firm and the government, right? And a firm wants to engage in some type of behavior or print or film production and wants to make money, and a government that doesn't, okay? Now, I will also tell you that the overwhelming majority of these types of cases actually involve local government, right? So a local ordinance, a county ordinance, village, township, city, what have you. And the law, it's kind of, we kind of joke about, it's obscene, it's really not that big a deal. If you really connect this to money-making enterprises, it actually tends to be a pretty big issue. Okay, now, with that said, and I'll have copies for you on Wednesday, and I've also uploaded this to Brightspace. I've got just a quick handout on the First Amendment and obscenity, and it actually has the two chief tests the United States Supreme Court has used to determine obscenity, okay? And you've probably heard this phrase, and maybe you didn't know where it came from, but you've heard somebody say, "I know it when I see it," right? Now, this is actually a very famous statement made by Justice Potter Stewart, and he was evaluating a case, and I'll paraphrase a little bit, but he was having trouble determining what is hardcore pornography, and he says, it's hard to define, but I know it when I see it. And actually, in the case that was involved, he says, that's not it. He says, I know it when I see it, and that's not it. So you can kind of imagine in these types of cases, especially through the 1960s, where the Supreme Court just, they all went into chambers and looked at the evidence, and the evidence would have been the movie or the book or something like that, and they kind of got to see it and see what it is. If you really think about it, it kind of puts attaches a laugh to the United States Supreme Court case law. Okay, so the first one that you're going to want to look at is the Roth test. Now, the Supreme Court had really struggled until 1957 to put some type of test into place to determine what is and what is not obscene. Now again, if it's obscene, by definition, government can prohibit it, criminalize it, whatever, okay? If it's not obscene, it can be regulated, but it cannot be prohibited. Okay, no, so just to kind of fast forward to 2018, you think about nude magazines, right? Depicting nude men or nude women, doesn't really matter. All right, which you already know now, of course, in the year 2018, is that type of material is available, so you can't prohibit it, its manufacture, print, distribution, etc., but you can regulate it. So for instance, only those who are 18 can't purchase. Okay, so you kind of get the idea. So what we're really only going to focus on is essentially what can be criminalized, prohibited, etc. So look at the Roth test. All right, and just go ahead and read it to you. Whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interest. And by the way, that term is spelled correct. It's not a term you hear very often, but prurient means erotic, salacious, that type of thing, emotions of exoticism, that type of thing. Okay, now, if you break this down, all right, imagine being in a court case, at least between 1957 and 1973, you would have to define what is an average person. And since a lot of that, I kind of gave this away a little bit ago, since most of these cases involve local governments, you're like, okay, well, what's a community standard? What's a contemporary community standard? So if you think about it, right, and by the way, this pops up again in the Miller test. Okay, it's some very interesting law, right? Contemporary means now, which means even in the same community, what is and what was obscene could be two different things. So as to say, the Roth test allows for change, right? So in 1957, right, maybe that article, be it magazine, book, print, device, whatever, all right, movie, might be okay today, whereas in yesteryear, it wasn't okay. Yesteryear, it was obscene. Today, maybe not so much, okay? Now, community standards. Okay, this is a tricky part, right? Now, think about it this way. Medina, Ohio versus New York City. Two different communities. So what you see here with the Roth test is a lot of flexibility, right? Within the same community, things can change, and two communities might be treated differently, right? So you can kind of scratch your head and you're saying, well, maybe, are you telling me the same book might be obscene in Medina and maybe it's okay in New York City? Yeah, under the Roth test, that was possible. And of course, that book in New York City in the 1920s might not have been okay, but in 1957 it's okay. So you see a lot of flexibility. Okay, the dominant theme. Now this is also one of these tricky parts. You can kind of imagine Potter Stewart's, there was a 1960s case when he made the comment. I know it when I see it. Him kind of wrestling with this. Okay, I got to look at the dominant theme. What's the dominant theme? So you're kind of asking the Supreme Court to each Supreme Court justice to kind of dig out of their talent set, the ability to judge art, I guess, and kind of tough. Prurient interest really isn't that hard. I mean, eroticism is eroticism, excitement, sexual excitement, that kind of thing. Okay, now, problems with the Roth test. For the most part, we've really kind of examined them, all right? It just was too narrow, all right? It's just too narrow. Things can change over time. Each individual community, okay? Now, what you're going to see is that in 1973, the Supreme Court, by 1973, the United States Supreme Court knew they had to come up with something that was working a lot better, okay? Now, we also have to be honest about American history and counterculture and pop culture at that time. More and more things, right, were coming out. More books, more movies, more magazines, more devices, more activities in some of those red light district bars, if you will, okay? So the envelope was getting pushed, all right? And remember, local governments, and some of this was state stuff, right? Almost none of it was federal, by the way. But some of the states, so you've got businesses pushing the envelope. Because again, this is about money. I know sometimes we kind of kid about it, what's right and wrong, what you want kids to see, and that type of thing. But this is about money. Let's not kid ourselves. This is about real money. So like in a media class or an advertising class, advertising law class, we'd spend a lot more time talking about this and talk about the real money issues that were kind of behind this kind of stuff. Okay, so if you look at the Miller test, they include the Roth test more or less and then add two other things, okay? But there's a reason we're going through it. So again, looking at the Miller test, and it's right there on your sheet. Whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interest and, all right, a second qualifier, the work portrays sexual conduct in a patently offensive way, and, number three, the work lacks serious literary, artistic, political, or scientific value. All right, and I've got a little note there saying it's quote unquote the lapse test. All right, now think about what the Supreme Court did here in the Miller case, right? What they did is they actually made it harder for any government, state, local, federal, to show something is obscene and therefore could be prohibited. Because if you have this requirement, it's a little bit easier, just under the Roth test. But since they're adding requirements, it becomes even more difficult to show that something is obscene, that you can prohibit it, okay? Now, so think about it this way. Think about being a magazine publisher or a film distribution house or an author or something like that, all right? You get past test part 1 of the Miller test, right? You're like, okay, so far so good. Then number 2, patently sexual conduct in a patently offensive way. Sexual conduct is sexual conduct. That's not a big one. The third one is the one that really, right, opened up the scope of what would be permissible. All right, and then therefore on the flip side, really contracted what is really legally obscene. Okay, now think about it this way. Any work, the magazine, the film, the book, right, the device, what takes place at a particular bar, right, or entertainment outlet, what if you will, would have to lack serious literary, artistic, political, or scientific value. Okay? Now, what any lawyer working in this area will tell you, advertising attorneys, media attorneys, things like that, what they'll tell you is that generally you can get almost anything through the artistic term. So everything's going to have some kind of art value, right? Whether it's literary, right? Pictures, lighting, the films, drama, acting, that type of thing. So much will be able to be allowed, if you will. Okay? So, if you think about it, what the Miller test did is it expanded what is permissible, books, movies, right? Magazines, devices, etc., and really shrinks what you can really outlaw, what you can prohibit, all right? Okay, and largely because of literary and artistic value, and artistic being really the key, right? I might ask you a multiple choice question on that. Okay, so essentially, which part of the lapse test really allows for the most broadening of scope in terms of what is permissible? Okay, now. That doesn't necessarily mean that everything is permissible, okay? The one thing that we can all say, right? Attorneys, political scientists, what have you, will say, and I should say we as a society would probably agree to, and that lawyers can all agree to as well, is that the one thing that's never permissible is child pornography, all right? You can't make it. You can't distribute it, all right? It could be all voluntary. It doesn't matter. You cannot do it, all right? That's illegal everywhere, right? And it's going to fail, all right, the Miller test every single time, okay? So with that said, you know, you think about child pornography, it's not going to have any serious literary, artistic, political, or scientific value. Again, the Roth test would make it illegal on its own. Okay, so child pornography. Now, outside of child pornography, frankly, there isn't much that you can really criminalize, prohibit, not only in terms of manufacture, distribution, importation, etc. But again, you know, one of the things you have to keep in mind is that really this kind of stuff is really about money. Okay, so let's switch gears. All right. And move on to the Fourth Amendment. Okay, now, the Fourth Amendment deals with search and seizure, okay? Now, what I like to tell students up front, whether it's a class like this here, Government and Politics in the United States, or a more basic constitutional law course, or even the true criminal procedure course, is that the Fourth Amendment deals with stuff, things, okay? Not what I'm saying, all right? Not me being interrogated. That's the Fifth Amendment, all right? But the Fourth Amendment is stuff, the gun, the knife, the blood, the dead body, Powerade, the phone, that type of thing. It's stuff-oriented, okay? So think of it this way. The idea is that law enforcement, they're actually trying to find something. They're getting something. Okay. Now, one of the things the framers believed to be a real infringement upon human rights, and really the Magna Carta, that kind of really sets the stage for even our modern civil rights and civil liberties today, was this idea that law enforcement could just come in and start searching, right? Your home could just start searching stuff. All right, now we'll get into automobiles, which obviously weren't around then, but anything, no privacy, no concern for privacy. All right, now, with that said, right, if you read the Fourth Amendment, you will find the warrant requirement. Okay, now, with that said, the warrant requirement requires law enforcement to have a warrant to conduct the search, right? So if law enforcement comes to your house, says, I want to search, they better have a warrant. Okay, now there are some exceptions, and we're going to get into just a few of them. Again, this isn't a criminal procedure course, so we're not going to dig too deep. Okay, however, all right, they must have a warrant. Now, a couple things I want to say about warrants. All right, warrants have to be based on probable cause. All right, hint, hint, hint. They have to be based on probable cause. Probable cause, by definition, right? And I'll give you the definition here, and then you can get it down in your notes, and I'll tell you kind of in practicality how it really works. Reliable evidence leading a reasonable person to believe that a crime has been committed more likely than not. All right? Reliable evidence leading a reasonable person to believe a crime has been committed more likely than not. Okay, now essentially, you got to go get a warrant from a judge, right? If you're a law enforcement officer, you got to go to the judge. Say, Judge, I've got reliable evidence leading a reasonable person, you, right, Judge, Mr. or Madam Judge, to believe that a crime has been committed more likely than not. So anyway, in practicality, by a 51% standard, hey, Judge, there's something in there, right? I've got maybe somebody that signed an affidavit saying, I know this is in there, right? They've got other evidence, other corroborating evidence to get in there. So they have to have that warrant. Now, again, if law enforcement knock on your door and say, we would like to search, and they don't have a warrant, then they don't have probable cause. Okay? You know that they do not have probable cause. Okay, now, that's the warrant requirement. It's in the Fourth Amendment, fairly blatant. Okay? Now, obvious rather, maybe not blatant, obvious. Okay, what about the exclusionary rule? Now, the exclusionary rule is one of these constitutional rules, right, well embedded in our law, that's not in the Constitution, kind of like the power of judicial review, right, and some of the other civil rights and civil liberties we're going to talk about here in a second. Okay, so the exclusionary rule had been kind of around, but it hadn't really been part of our framework of constitutional law until 1914 in the Weeks versus United States decision. Now, what's important to realize this starts out, this is a federal case. And by the way, anytime you see U.S. in the name, it's a case involving the U.S. government. And if it's a criminal case, it's the federal government that's actually prosecuting. Okay. The exclusionary rule says the following. If evidence has been illegally obtained, right, it cannot be used against the defendant at trial, right? So in other words, let's say law enforcement just comes into your house, starts searching, they find guns, dead body, drugs, right there in your living room, right? If they were supposed to have a warrant, didn't have a warrant, that illegally obtained evidence cannot be used at trial. Now, can you